Good afternoon, everyone. I'm Aaron Connor.
I'm
Here.
Pierro.
Frank is joining us from the shed. No, that's his office.
Hi, guys.
Today's another day in or the final day, really, in our Medicaid Monday series for this month. If you haven't seen them all, they're available on our YouTube channel. Here they all are, and today's will be added in a few days from now. But today, we're going to talk about what happens when you get denied. Well, if you get denied, you need an attorney. And here are all of our attorneys. Not all of our attorneys practice in this area. We'll be a little more specific about that. But you need an application. We have attorneys for that. You need some estate planning work. We have application or attorneys for that. And attorneys who do all practice areas really within our specialty of estate planning, business planning, trust and estate litigation, elder law, and Medicaid work.
For some applications, Aaron, you need an attorney to keep from being denied.
Exactly.
Depending upon how complicated the application is, if you truly have nothing and you have no income or assets to protect, and you just are filing for the straight Medicaid benefits and there's no planning involved, then perhaps an attorney doesn't need to be part of the application. But we're going to see some situations today where in the preparation for your application, it takes planning, it takes careful consideration, not only of the assets and income, but of the actual programs that you're going to be applying for if it's home health care. And so with that.
So just a brief word, we're talking again about Medicaid today. I know a lot of people sometimes get confused between Medicare and Medicaid. There are Medicare denials, specifically the one we see the most is whether rehabilitation status is going to continue. Okay, that can be appealed. Sometimes we appeal it just to give us more time to get some Medicaid planning in place. But today we're focusing on Medicaid, which is going to provide long-term care services and not Medicare. So to be eligible for Medicaid, I'm sure you've heard this before if you've watched this series. These are your numbers. Okay, essentially 904 in income if it's a home care case. If you're in a nursing home, you get to keep $50. And for whatever reason, that's never changed in over 50 years. There's a minimum monthly needs allowance, which is, again, happens generally when we have a well spouse, or it happens when we have a well spouse. If that well spouse does not make $32.59.50, income from the care recipient can be shifted to that person to get them to that level. An individual gets to keep $15,900. Again, there are certain exemptions for that. We've been over those. And again, if there's people at home, you don't get to double everything. You get essentially 150% of the other resource limit. And if there's a well spouse, you get to keep essentially $75,000 plus your house if you're living in the community. All right, Frank, you've done a Medicaid application. What are some of the reasons you can get denied?
So you could be denied for having too much income. Generally, that's only in a nursing home context, right? Because if we have a home care case, we can use a pooled trust to accept your excess income. But in a nursing home scenario, there are cases where people have very high incomes, and it's entirely possible that given certain circumstances, their income may actually be higher than the cost of care needed for the nursing home. If that did happen, that would be a case where you would be denied due to excess income. More often than not, though, if we're going to get a denial, it's usually because of excess assets. So just as the previous slide showed, to be eligible, if you're one person, it's $15,900 or less. So if, say, you applied and you had $50,000, well, then you're not eligible because you're not under that asset limit. They're going to deny you. Sometimes we see a case where we do get an approval, but now there's a look-back penalty period. So in our promissory note cases that we have used for a very long time for nursing home cases, soon to be home care cases, once the new rules takes effect, we're going to see approvals, but with penalty periods that we set up on purpose. So sometimes the calculation of the penalty, even if we're anticipating one, may not be correct. And then the one that I think we're seeing the most advocacy on generally now is that we get that Medicaid approval for home care services, but people aren't being awarded the sufficient hours that they need to stay in the community. So we actually have to go through litigation and potentially a fair hearing, which we're going to get to in this program, to kind of ask for more hours to get the appropriate level of care in the home for the person to stay there and remain safe.
Excellent. So what do you do if you get denied for any of those reasons? Well, you want to appeal because you want to get what you thought you were going to get. And you can't do that by sitting on your hands. We'll talk about them some here, but it's important to know that in any of these areas, there's a time limit for an appeal. Okay, so you can't wait a year. In most situations, you can't wait months. You need to appeal ASAP to get the process working, not only because your rights will be foreclosed if you don't, but just the amount of time it will take to correct the problem. So it's very important to get out in front of these and get the appeal moving. If it's an appeal because you've been determined not eligible, we've seen a few of these lately that have been a little bit strange in that they have been reasons that have never been cited before, meaning that they've gone to such a level of detail and granularity that they're asking about $50 ATM withdrawals, which certainly they have the right to do, but most applications we see, they don't get to that level. And some people like to pay cash for things.
Well, that's an issue that does come up, and Frank can address that one. But the first document that you're going to receive is the notice of determination from the county. That's a crucial document, and you have to read it carefully and follow the instructions. That's going to give you the groundwork for your appeal, and you can request something called an agency conference if you want to just talk to the brass at the Department of Social Services or the Human Resource Administration. You can have an agency conference if you think they missed something in their notice of determination. You just want to bring it to light and make sure they're aware of the facts and are deciding it on the right bases. But Frank, in that notice, it also lays out your rights of appeal.
Correct.
And that's what our clients have to follow. And what is that timetable?
So generally, it depends on what kind of action the county is taking or not taking. So generally, we're going to see rights of appeal range from 60 days to 120. And in this context, where generally we're getting involved the most, it would be actually call that fair hearing. That's 120 days. And the nice thing on the notice that it will actually say on the either back or on the second or third page, kind of depending on what your notice looks like, it'll actually tell you which day is the last one that you have to file for the hearing. So they make it pretty clear if you go through all the wording to get to it of when you have to make the decision by and get your appeal in.
Right, and I do want to also highlight the third one on this slide, because just because you've been deemed eligible for Medicaid does not never ever mean that you will not need to appeal something. So generally speaking, we don't see people's condition improve over time. It tends to get worse, and that generally means that they need more care. So at certain times, we ask for a reassessment to get more hours of care for the person. A lot of times that is denied, and then you have an appeal for someone who maybe have been on Medicaid for 2, 3, 5, 10 years.
Mm-hmm.
So,
Frank, there may actually be a time when you want to file a notice of fair hearing, a request for a fair hearing, even before you get a determination. We talked about timeframes in our prior sessions on Medicaid Mondays, the timeframe for a home care application and when the county has to turn that application around. Same for a nursing home application. But very often the counties get backlogged, and you get to the 45-day mark, they're supposed to have a decision to you and they don't, but people need care. So what do you do?
So it's kind of a give and take, right? We want to have a good working relationship with the counties because we want to make sure that all of our stuff is being processed quickly and correctly. But kind of what you're alluding to, Lou, right? If we do have a county that's just delaying and they're not asking for things, they're just taking too long, then usually what we try to do is we'll place that phone call first just to try to check in. And if we don't then get some movement on the case to our either quickly enough or to our liking, then another avenue we have is we actually file the hearing, or file for the hearing, that's a better way to put that, file for the hearing in advance of the decision, saying the county is taking too long. Because generally what the county does not want to have to do is go before a judge to explain why they're taking too long to do something. Because for the most part, their reasoning generally is, well, we have a lot to do. Well, so does everyone else. So usually that will then speed up the process. We don't like to go down that avenue if we don't have to, but it is one that we have.
all right, so let's say you have an adverse determination, denial, or no increase in hours. Frank, do we go right to the courtroom, get in front of a judge in a robe immediately?
Not anymore. We used to be able to do that, but then they changed the rules on everybody to make this harder. So Unfortunately, now we can't just file for that hearing immediately. You have to exhaust your appeal rights. So if we're dealing with particularly a home care case where we're dealing with a managed long-term care company, we have to then first do what's called an internal appeal, where we bundle a whole bunch of documents and supporting medical records and a brief and all kinds of things to the plan, saying why they're wrong. And then we have to give the plan a time to look over everything and kind of decide whether they really are sticking to that decision or not. And only if they then come back with a final adverse decision where they say, you know what, you're not correct, we're not giving you what you want, only after that final adverse determination can we go to that fair hearing and file for it.
And it's also important to note that a plan just can't say, we're just reducing your hours, right? They have to go through a process to do that.
Correct. And Aaron, this is, I think, one avenue where you really excel with explaining it to clients is if there's a previous approval, or if there's already services in place, like if you're already paying for assistance at home or Medicaid's already providing assistance, it's very hard to then justify when you're the plan that now this person does not need these services. Because as you kind of already said, it's not unheard of that people get better, but generally there just isn't really how the course of their prognosis goes.
Now, we've gone 14 minutes without mentioning COVID. But I think at this point,
Is that a record?
It's a record. I think at this point, it's important to note that there are pre-COVID rules and during COVID rules, and that there are prohibitions against the government. Federal government has prohibited New York State and all states from reducing Medicaid benefits during the pandemic. So there has basically been a freeze on a lot of the actions that we're talking about right now. That will come back as soon as we're clear of this COVID period.
That's true. As long as the emergency declaration is in place, there are certain rules that have been changed, and they allow you to certify certain things, right, Frank?
Yeah, so we are not seeing as many requests for, every check or every bank statement to the same degree we were before the pandemic. The biggest change, I think, more than anything, is the counties are allowing applicants to attest to many more things than they used to be able to, just because of with everyone working remotely or not wanting to go out of their home or not being able to go to the bank. It's even harder to get some documentation that sometimes we do need. So for now, the counties are allowing an attestation where you sign a statement saying something is true in place of the hard copy documents. But again, once the pandemic is over, I can't see that staying in place to the same degree that it is now.
I think we'll see an uptick in fair hearings after the pandemic is over for people who maybe attested to something that they thought was correct, or maybe they knew wasn't correct, and received benefits that they weren't actually entitled to. So we'll have to see how that plays out. But I do think that attestation is going to come back to haunt at least a few people out there. So next slide. It's important that this is a very, very tight window for the initial determination. Okay, so you must appeal within 10 days of the notice. Again, things don't get better if you wait. So you need to be proactive. If you get a denial, or if you get that you're going to reduce or stop services, and the stop services is pretty unusual. It does happen, but we do see reductions because these companies or plans are run by for-profit companies. At the end of the day, they're trying to make a dollar. A lot of them. Yeah. And you can't do that if you're providing all the care everybody needs, unfortunately.
And the key to this one is once you've been awarded hours and they try to curtail your hours, you are entitled to something called aid continuing. You have to request it, but you can maintain service at the given levels until your appeal is determined. So it's very important when you're going in to appeal a reduction in care that you ask for aid continuing.
Correct. Very good point. So if it's not a reduction, there's a different time period. What, Frank, you want to go with this one?
Sure. So if they're denying a new service or they're denying an increase to an existing service, so this is the case we've been talking about, where somebody's on services, now they need some more help because something has happened, and now they need more help at home. If the plan doubles down and says your existing 30 hours that you were getting previously is still good for to service your needs, and we're not giving you that increase, now you have the 60 days. Just to note kind of on the last slide, you can continue to ask for aid continuing, but if they're not reducing your benefit, it's not nearly as crucial as if they're taking something away or they're reducing it. But it is just, you can still ask for aid continuing, even if it doesn't necessarily come up the same way.
And from there, you're going to go into this eternal appeals process, which is not exactly like a court filing, but it's going to be based on all the same evidence you would use in a court filing. It's going to be affidavits talking about the need for care and the things that have gone wrong. It will be medical documentation. Their doctor will likely be involved, saying that this person needs 24-hour care or 12 hours a day, those types of things. And we're going to talk about why someone may be unsafe given the level of hours that have been provided. So you're going to present all the same arguments you would in a fair hearing, but you're going to do it in what we would deem a more informal way. And we're not worried about the rules of evidence and those types of things, but we're going to make the same arguments.
This is where preparation comes in. If you're dealing with community-based Medicaid benefits and you want to get the appropriate number of hours, we work very closely with treating physicians and other home care providers to build the case before we apply, so that all of the documentation, the physician's affidavit, judging tasks and task-based assessments, all of that is in the record at the time of application, so that when we go to the record on appeal, an internal appeal or a fair hearing, we have the record already built, and they're basing their determinations in the face of a medical doctor who is going to say the person needs 12 or 24 hours. They then have to go against that medical evidence. This is one area where new rules, potentially, if they're enforced, are going to take away the treating physician's ability to prepare our cases for our clients and go to an independent assessment physician. That's one of the changes that we talked about in the home care rules.
That's true. But certainly on an appeal, we're going to put everything we can in. We will be using that treating physician there, but we will not have the ability to do it in the beginning. It's also important that there's some rules of disclosure here. So you're entitled to the information that the decision was based on. And this is important because essentially when you go further down the road, it becomes more incumbent on the plan to justify what they've done. And if you can point out deficiencies in what they've done or what they've looked at or how they've come to their conclusion in the internal appeals process, you're likely to head off that because frankly, no one wants to look bad in front of an impartial hearing officer. So it's important to get that file. They may have missed some things and then try to point those out. So Frank, you want to talk about more about this?
Sure. So it's more timing. So if you're just doing what's called a standard appeal, because there are different avenues you can ask for. So one would be an expedited appeal, which comes up in the next slide, or a standard appeal. So if we're not in a place where someone's life or safety is at risk, they have the plan, whoever is making that decision has 30 days from the receipt of the appeal to make a decision and then inform you of it in writing. Sometimes the plan may ask for additional time because sometimes they need to see additional things. So if one thing that we argue is their medical condition has changed, or now they're not sleeping through the night, something like that, and that's why we're asking for increased care, sometimes the plans will say, well, we need to get our evaluator in there to see what's going on, or we need to do a sleep study or something like that. So sometimes the 30 days is enough, sometimes it isn't, and some additional time has to be asked for. I will say, when this was generally discussed with the hearing officer, they are usually cognizant of the issues and the safety, and they try to do their best to keep things moving. But obviously, with everything else with this system, some things take time.
And if you qualify for that expedited appeal, easy for me to say, things happen a little faster.
Yeah, so now then they get that window really dropped to, they have to decide within 72 hours. Again, they could still ask for that extension up to the 14 days, because if we're talking like that sleep study, just for instance, right, that's usually not going to be able to be scheduled and evaluated all within 72 hours. But it does put a lot more pressure on the plan to make a decision and to make it faster.
All right. So after, let's say we are unsuccessful, because sometimes we are and sometimes we aren't, in convincing the plan that what they've done is the correct decision. Okay. At that point, when you've completed the internal appeal, have you exhausted your internal remedies?
You generally, if you do your internal appeal, that would exhaust. The other nice thing though is that the law doesn't basically hold it against you if the plan's not doing what they should be doing, right? If the plan is given a time frame and they don't abide by it, then you're deemed to that they have exhausted, that you have already exhausted your what you need to do, even if it wasn't really on you, it wasn't your wrongdoing, because you're the one that's harmed by this. So if the plan does not do what they're supposed to do when they're supposed to do it, now you can jump forward to that fair hearing in front of that impartial hearing officer.
Right. So it's taken us all of this time to get out from the plan and to someone who is not necessarily financially interested in the outcome of the determination. So at the fair hearing, who are we in front of?
Well, these days we're not in front of anybody. We're on the phone. But generally it is an administrative law judge. Usually the hearings, when they are held in person, they're down at the local Department of Social Service office. I have had one where I was in a room with a judge at the DSS office, and then the plan, their representative was on the phone. Now everybody's on the phone, but generally it's in front of an administrative law judge. And then the hearing is actually conducted over a phone system where everything is recorded, and then it's then later reviewed after the hearing is over.
Just want to point out that there are two different types of appeals. We're talking mostly about the managed long-term care system at this point in going through the internal appeals at an MLTC to get to a fair hearing. But if you are denied based upon simply financial eligibility, that goes right to fair hearing, because then you're not against the MLTC, you're against the county DSS. And we'll just distinguish a couple of those types of cases from the MLTC appeals.
Absolutely. Yes. So with these internal appeals that we're talking about, again, are for hours determinations, generally speaking. And we don't have that worry in a nursing home because you're either there or you're not there, right? So that's a good point. So most of the time when someone calls us and we haven't assisted them with an application and they've gotten to this point, a reduction in plan hours is a big problem. And they will say, well, there's more assistance being provided in the home for family or other such things. So we see these a lot, and we build a plan to make sure that when we come in, that we are constructing a plan and a case to bring about not a reduction and maybe an increase. Frank, we worked on an increase recently where we were successful in getting 24/7 care through a fair hearing process.
Correct. We had an older client. She is a very elderly lady. She was completely bedridden, has a lot of other underlying health issues going on, and the plan that she was in awarded her 12 hours of help, and that we tried to get them to increase it. They would not. So we worked with not only her agent under her power of attorney, but also her local care manager. And between our office, the care manager, the family, we were able to kind of put a very compelling package of documentation together. And we took it all the way to hearing, saying this lady needs 24-hour assistance. She cannot do anything for herself at this point. And I think one of the biggest positives we had in our favor where we had medical records that spanned, I think, almost a year, where her treating physician had put in writing that she needed to be turned in her bed every 2 hours to prevent bed sores and breakdown of her skin. So it was almost impossible for the plan to say that that they didn't need someone on site 24 hours if she needs to be turned every 2 hours and she couldn't do it herself. But that's the kind of level of things that we're seeing, where sometimes, even though logically to us it makes sense that somebody needs more help, sometimes the plans don't want to give it anyway.
Right. So that's a great success that we had in the home care arena. I know we've had several in the chronic care or nursing home arena. I did one very early on where there was a transfer to a disabled child that the county objected to, and we had to go down and educate them that that was an exempt transfer. We had one concerning an IRA for, I believe that was a nursing home application, about whether it was in payment status.
Yeah, I'd like to touch on that issue
Sure.
because it's an issue near and dear to my heart since I drove to Nassau County to do that fair hearing and lost. But the way the state treats this, and it's not the state, it's county by county. And the state is basing this on a 1998 General Information Service bulletin that they put out on IRAs and 401ks. Federal law says if your IRA is in periodic payment status, then it is exempt for Medicaid purposes. The question then becomes, what is periodic payment status? And we have IRS tables that determine required minimum distributions. And we had a client down in Nassau County who was older and she was receiving an IRA, and her life expectancy under the IRS table was 8.6 years. But there's a second table that Nassau County applied called the Social Services table, where her life expectancy was 3.54 years. That changed her required distribution or voluntary distribution, because it wasn't required under the IRS rules, from $4,350 to $10,569. If she was married, her distribution would have been $4,500 because they apply the IRS table for married people, but the DSS table for single people. No rational basis. This is unequal enforcement of the law. And I argued it to an administrative judge, and he went with the state's policy, quote unquote policy, which is really just a letter based on the 1998 GIS. The next level of appeal, if you want to go beyond the fair hearing, is to sue the state in Article 78. And I've done that several times, somewhat successfully, because usually you know your case is a winner by the time you get to that court process. But in Article 78, Aaron, is where you go beyond the fair hearing. In that case, the client did not want to go and pursue that level of appeal. Other clients do, and I'm looking for that client that wants to take up this issue because there was no administrative rulemaking. There are so many things wrong with the way they're applying the law so unequally from one person to the next, one county to the next. Frank, most of our counties use the IRS table. Certain ones use the DSS table.
That's correct. Another nice thing of the pandemic, even though there are not many, is because of those additional protections in place, the counties cannot use the social service table. They have to go on the kind of the least restrictive or the most generous to the client table. So right now we can't see them do that. But again, once the pandemic ends, it would not be surprising if they go back to doing the old practice of some using some table and others using a different one.
Knowing your rights is critical, and they have changed during this pandemic. So we need to learn that. And now we're waiting for the next round of rules coming out. And home care, community-based Medicaid is a lot of our thrust. We did a couple sessions on that already. But one thing you have to know is that New York State has different home care programs. One that is very popular for many people is the long-term home health care program. And that is now exempt so far from the new rules that are incoming. But it has a different set of rules than the personal care aid program. We did a fair hearing a few years ago where we went in and applied for the personal care aid program. The county used the rules for long-term home health care, which was the wrong set of rules. So it is not like you're dealing in all cases with experts on the other side. We deal with some very seasoned social service reps and some newbies who just got into the world and don't really have the background for that. And so you need to know, as the appellant, all of your rights. You can't rely on the other side to know the playing field because it is so complicated and you get all types of adversaries, Aaron. I think you can say that for being a litigator.
Absolutely.
You don't know what's on the other side. So you need to know your own rights and have a good advocate on your side to pursue these types of cases. And I hearken it back. If you're well prepared through the application, you'll be successful at fair hearing.
It's absolutely true. The product that goes in the first instance is very critical, and advising a client through the process and the home care process to make sure that they get as many hours as possible. You're not going to get that without a lawyer. And if it's a chronic care application, there may be transfers that have to be explained or have to be accounted for on the front end. So it's very important. We have our Medicaid attorneys up on the screen now. If you need assistance in any of these areas, or you have clients that need assistance in these areas, we're very happy to help.
And